Good morning. It's almost afternoon here in Washington, D.C. I hope that everybody can hear me. Sorry for the delay. I had to find some place to stand outside the Supreme Court building here, which I attended the oral arguments. And it is a fine morning here in D.C. It's a bit cold. I had to pull out my winter coat, but I did have the privilege of sitting through the oral arguments today for the Wayfair case. Quite exciting to hear both sides of the argument. We find a lot of, let me kind of say, I think my overall impressions, I'm sure everyone wants my overall impressions. My overall impressions are that the justices didn't really hear enough or a convincing enough argument to overturn Quill. Now, I don't know, they might. The opinion will come out by June. But at this point, I don't think there was anything really compelling or really significant, and a lot of the issues that came up were the impact to small business. In fact, it was very interesting that they talked about Amazon and the larger internet retailers that actually use not collecting sales tax as a way to put out of business smaller sellers who are bricks and mortar in the various jurisdictions, and now that they are everywhere, they want to collect everybody everywhere and want everybody to collect so that they can compete on a level playing field again. So again, kind of to the detriment, I think, of small business on both the front end and the back end. But what I did hear, I heard Justice Sotomayor. She was very concerned about small business. She was very concerned that the states had no way to collect the use tax from their customers that are residing in the state. Why does the state have to impose these types of requirements to everyone else? Can't you just collect the use tax that your residents owe within your state? Then I heard Justice Ginsburg. She was more so on the state side, that everything should be a level playing field. Why can't they just collect? Then from Justice Breyer, it was interesting. He indicated he read all of the briefs. First on the state side, he said that is absolutely correct. Then he read all the briefs on the side of Wayfair, and he said that's absolutely correct. So I think that shows the complexity of this case, that there are just a lot of considerations. One of the court's concerns is the retroactive application of Nexus. So from that perspective, the state did not think that there was going to be any problem at all. They thought that the states would only go forward on a prospective basis and would not be applying any rules retroactively. One of the briefs, they did indicate that one of the states already was trying to apply a retroactive treatment. So there was a lot of going back and forth, but I did see a great concern for the small business from the justices, from the bench. And my gut feeling is that Quill may not be overturned. There just wasn't enough there to overturn it. But a lot of talk about Congress. Why isn't Congress correcting? There was an amicus brief by about 4 congressmen that said, we are addressing, we put this off because we wanted to see what would happen in this case. But Congress believes that they can, or at least some of Congress believes that they can address it. The court on the bench, many believe that Congress could also address it effectively as well. So it will be interesting. There are a lot of constitutional arguments. I'm not an attorney. I'm headed to a lunch, and I'll get some other insights if I hear something that's very different or something very enlightening. I'll be sure to post it on this page for e-commerce sellers, sales tax for e-commerce sellers. But I think I was comforted that the bench really does not want to hurt small business. So that is a great thing. I did hear that, and the other thing I think that was funny, I'm trying to recollect something that, would be interesting for you. We had Breyer was very concerned on the cost. He said, what is the cost to compliance? He looks at the state side, and the state says it's $12. The cost of compliance is $12. And then if you looked at the defense, they said the cost is $250,000. And so the bench, they were really struggling with the ability to identify how much cost is there to collecting in all these states. The state tries to oversimplify it, and on the defense, they are obviously showing the complexity, which we all know there's a lot of complexity there. So again, overall, I think I have a good feeling that Quill may not be overturned. Hopefully Congress will come in and protect all of you small businesses out there that really don't want to have to be spending the cost to collect all these sales taxes everywhere. And hit your bottom line. In fact, one thing I will say before I go here, South Dakota indicated that one sale into the state should be enough to create nexus. One sale should be enough, and even if that one sale and that cost of compliance pushes that business into a loss position, one sale is enough. So that's what we're up against. The state says, oh no, we're not going to apply it retroactively, but I don't know how much faith I have in that, considering that comment. So hopefully the court will not overturn Quill, but we will find out in June. But I'm leaving feeling pretty good about it. There were arguments both sides again, but just nothing really compelling, I think, hopefully, that will overturn Quill. So thank you so much for spending these few minutes with me where I could report on the awesome experience I had in the courtroom today. And I will be writing an article for the Tax Advisor, the AICPA publication, the SALT column. And I will see you next time. Again, if I hear anything else or anything new or something significant, I'll post it. Thanks so much. Bye-bye.